Hey there, ready to test your knowledge? Let's test your knowledge on California Real Estate Exam Cheat Sheet PDF 2026 Key Facts You Need on. Test. Question 1. A contract that does not have all the necessary elements of a contract is A. Valid, B. Void, C. Enforceable by insinuation, D. Legally binding. The correct answer is void. A contract missing necessary elements is void and unenforceable by either party. Question 2. Leanne entered into a contract that called for $1,000 in monetary damages if the contract was breached. The $1,000 in the contract is referred to as A. Retainer fee, B. Breach fine, C. Liquidated damages, D. Lis Pinden. The correct answer is liquidated damages. A specified amount of monetary compensation, like earnest money, to be paid upon a breach of contract is referred to as liquidated damages. Question 3. After the offer and acceptance when the terms of a contract are in the process of being completed, and prior to closing the contract is said to be A. Executory, B. Amended, C. Rescinded, D. Lis Pinden. The correct answer is executory. When the terms of a contract are in the process of being completed, the contract is said to be executory. Question 4. Eric rents an apartment at only 17 years old. The lease agreement contract is voidable because Eric is not of legal age to enter a contract, but who has the ability to avoid the agreement? A. The landlord, B. Eric, C. A lawyer, D. No one. The correct answer is Eric. A contract with a minor is voidable. However, the minor is the only one that is able to void the contract. Question 5. Sharon made an offer on her dream home, and to show the seller she was a serious buyer, she offered a sum of money to be held in escrow that she will forfeit if she does not fulfill her end of the deal. What is the sum of money to be held in escrow as a good faith deposit called? A. Pre-funding deposit, B. Broker deposit, C. Earnest money, D. Purchase promise deposit. The correct answer is earnest money. Earnest money is held in escrow as a good faith deposit which is applied toward the purchase price at closing. Question 6. Once all terms of a contract have been fulfilled and the transaction has closed, the contract status is said to be fully A. Rescinded, B. Executed, C. Insured, D. Amended. The correct answer is executed. Once all terms have been fulfilled and the transaction closed, the contract is fully executed. Question 7. John signs a 6-month lease on an apartment beginning January 1st and ending June 30th. His lease does not automatically renew and no notice is required on his part to vacate on the expiration date. What type of lease did John sign? A. Estate at will, B. Estate from period to period, C. Estate for months, D. Estate for years. The correct answer is estate for years. An estate for years is a lease for a fixed period of time that does not automatically renew and requires no notice to terminate at the end of the term. Question 8. What duty does an agent acting as a property manager owe a property owner? A. Principal duties. B. Fiduciary duties. C. Legal duties. D. Regulatory duties. The correct answer is fiduciary duties. A property management agreement creates a general agency. Therefore, a property manager owes the property owner fiduciary duties to act in their best interest. Question 9. A property management contract should include all of the following except A. Signatures of the property owner and licensee. B. Duration of the agreement. C. Signature of the tenant. D. Management fee. The correct answer is signature of the tenant. The property management agreement is an employment contract between the owner and the agent. A tenant will sign a lease but not the property management. Question 10. Wants to transfer the title of her property to her granddaughter. Which of the following are ways to voluntarily transfer title to a property? A. Sales contract will sizen. B. Will grant deed. C. Title certificate escheat deed. D. Escheat will grant. The correct answer is will grant deed. Title to property can be voluntarily transferred by a will, grant, or deed.